with the same appearances, except the jury's not here, and we're here to talk about instructions and verdicts. And the district attorney has requested a multitude of lesser included offenses. Are any or all of them opposed?
Judge, I'm looking at their, So I have count one, just the first degree, the first degree reckless homicide. I didn't see any lesser included on that.
They asked for 1020. Did you get the written request for instructions?
I did.
They asked for 1022. Oh, yeah, there was an email last night. Did you get that?
I did.
Okay, they asked for 1022, which is not the standard for first degree reckless homicide. It's the standard for first degree with a lesser included of second.
Okay.
Okay.
We're not asking for that, but I understand the court may get it.
Okay. Are you objecting to its giving?
Yes.
Want to discuss it briefly, or just impose or argue, object for the record?
I guess I would just object for the record, Judge.
Okay. All right, then. I'm not going to decide right now because I just got your filing this morning, which was sent to the clerk in Kenosha. They sent them to me directly, and I know you're not familiar with that procedure. So,
Okay.
and actually, I wish less people had my email right now. But I think that's probably a common feeling. I will. What I plan to do is to send at some point tomorrow. I will send you what I expect to deliver as the final instructions and verdicts, and I would just given the evidence, I'll leave it at that. And then we probably will have what I hope will be a brief discussion on Monday about it, and at least you'll have I guess I will talk about it for a minute. The difference between first and second degree, and you're asking that I submit second degree, and it's in the instruction itself on the bottom of, well, I don't want to say bottom because I don't have them displayed as they would on the page, but on instruction, the instruction you've requested, which is 1022, under the heading difference between first and second degree reckless homicide, it says the difference between first and second degree reckless homicide is that the first degree offense requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. And of course the standard for submitting the lesser is that there's ground in the evidence to acquit on the greater and still convict on the lesser, Where's the absence of evidence of utter disregard for human life?
Judge, there was a line of questioning on the cross-examination of the defendant in which Attorney Binger asked, I believe in regards to each person shot or shot at, except for that of Mr. McGinnis, I suppose, if the defendant, I can't remember the exact wording, but if he even cared if he killed the person alluded to. So I believe that the defendant denied that he said he had to shoot him. He denied that he did not care about their life. So I believe the jury could find, based on that line of questioning, as well as just the evidence in general, that the defendant did not have an utter disregard for human life, as he testified. He testified that he essentially had regard for human life because he felt he had to do it, and he didn't really want to kill anyone.
Well, let's hear from the defense.
Judge, element 3 is the circumstances of the conduct showed the utter disregard for human life. And in terms of the evidence in the case, I think the testimony was he didn't want to have to do it, but he did it to defend himself. So, as I said in our instructions, I don't think that there has been any evidence offered which would support the lesser included on count 1. So I would ask the court give 1020, which is the first-degree reckless homicide charge, along with the self-defense instruction, and that'd be that, because I think that's what the evidence shows.
I'm going to do a colloquy with your client when we get done with all this. And don't let me forget, please.
I've discussed it with him.
Yeah, but I got to talk to him personally. The instructions says, in determining whether the circumstances of the conduct, and that's a correct point, the conduct showed utter disregard for human life, consider these factors: what the defendant was doing. He was firing a gun into, let's see, this is count 1, so we're talking about Mr. Rosenbaum. He's firing a firearm 4 times into a human being with fatal consequences. Why he was engaged in that conduct, how dangerous the conduct was, well, that's self-evident. How obvious was the danger, that's self-evident. Whether the conduct showed any regard for life, and all facts and circumstances. I don't see it, and I don't see it. Help me out where I'm going wrong.
Well, Judge, he was asked if he, not only did he, how he felt about killing them, but if he knew that his conduct would have killed him, and that firing that gun would have killed someone.
This element is on first degree, which is what we're not talking about, is whether he knew or was practically certain, and we're talking about reckless endanger or reckless homicide. So, I mean, to fire a gun 4 times into somebody, you don't think you'd know or have or be practically certain that that could have fatal consequences?
I would, but the defendant denied that it did, that it would.
He didn't. I didn't hear him deny it. He said he was protecting his own life. I thought he was, when he was being asked repeatedly, and correct me if I'm wrong, he was asked repeatedly questions along the line that you indicate, and he responded, I was trying to defend my life.
He was also asked the line of questioning, you knew if you shot 4 shots that you would kill him, and he denied that he would have that knowledge. So I mean, I agree that, I mean, I obviously think that it's utter disregard, because that's what we charged it as, and that's what we have presented to the jury, but I believe a reasonable jury and a reasonable juror could, based on the defendant's own testimony, not find utter disregard for human life. And that's the standard, not what we think, but what a juror could do.
I wish I knew the exact answers that were given. I'm not sure, and I when I say that It doesn't mean I'm embracing your interpretation of what that would mean, but I would want to be sure exactly what was said anyway. So, are you able to identify when in the examination? Because you had a very lengthy examination.
Check my notes.
And, unless it's crystal clear, my suspicion would be if it turned out that the defendant would be acquitted, well, not acquitted, but if the jury returned a verdict on second-degree reckless endangerment with this description of what constitutes the crime, if they returned a guilty verdict over the defendant's objection, I would expect to be reversed.
On second-degree reckless endangerment?
Yes, or homicide, I'm sorry.
So, you're saying if the jury finds the lesser
On this charge,
and the defendant objected,
over the defendant's objection,
and you accepted it,
right?
you felt it would be reversed?
Yes. Unless you can come up with this crystal clear language that the defendant, and again, we're back to the circumstances of the defendant's conduct showed utter disregard for human life. So I think his thoughts on the subject would be relevant, would be a legitimate factor, but when I consider the others, what he was doing, firing into somebody 4 times, why he was engaged in it, there's dispute about that, but either it was it would certainly be reckless under any circumstances, and except under privileged circumstances. How dangerous it was, how obvious was the danger, and whether the conduct showed any regard for human life. And if anything, it seems to me he would have indicated, if you interpreted his answer, it would be an indifference. Although he did say at one point that he didn't want to kill anybody, but it would be an indifference, because when he's asked about his intent, what was the question you're saying again?
There was a line of questioning on if he cared about killing someone or cared in that regard. And there was a line of questioning is you knew that firing the gun could cause death, and I believe he denied or indicated he didn't know.
I don't remember that. Did
Everything that he said, I mean, the reality is everything was an intentional act. Now, they haven't charged it that way, and I appreciate that. But looking at the definition of utter disregard under the statute, I'm not going to repeat. I'm going to hold the same ground that you've already done. Firing 4 shots, we have evidence that the man grabbed the barrel of the gun. So we're talking about a distance of inches, not always feet, but in some situations, inches. It is the only logical conclusion would be that a person would believe that conduct, if they were convicted, would show an utter disregard for human life. If self-defense isn't accepted, there's no other reasonable conclusion that can be drawn from firing a gun somewhere between 1 and 4 feet, all the way down to inches, by the soot on his hand. So I think that's what the evidence showed, and I think that's really the only evidence regarding the utter disregard portion of the statute. So,
if the defense is willing to stipulate to the third element, then that's fine. We can go for it that way. But it seems they're not arguing it. And if we want to go that way, then we can.
Conversations with lawyers are always interesting. And
if they're not willing to stipulate, then obviously there must be some disagreement, or they must be trying to argue it. So I believe that there is a basis. I cannot recall at this moment precisely where in the cross-examination it
Well,
occurred.
yeah,
Obviously,
you
it was
should-
lengthy, and I was the one conducting it.
The examination, as I recommend, as I recollect it, was that the defendant was repeatedly asked about the question about his thoughts on the subject of the death or survival of the target, and invariably responded that he was trying to defend himself and that he'd be killed if he didn't. And if anything, I would interpret it as an indifference towards the outcome with respect to the target, which is not identical to utter disregard.
Right. Right. So if he's indicating he has an indifference, that would be second-degree reckless homicide.
Now, it would be one factor, and I don't, even if I granted what, I just don't think it's appropriate. And as I'll repeat my statement, if I were to give this instruction over the objection of the defense and the jury found a verdict on it, I would expect to be reversed.
Well, are we in agreement that element 3 is present?
Well, don't ask me. I'm not in a position to agree to anything. I'm not going to give that instruction. Or submit that verdict. 1345 and 1347. Second-degree reckless endangerment.
So it's essentially the same issue.
Yeah, it is. So, any additional argument on that?
It would be the same for count 3 as well. Well, counsel raised a good point to me that he claims he didn't even know Mr. McGinnis was there. So he's firing a weapon whose he admits does not know the capabilities of. He admits he doesn't know how the bullets can react, that he did not know a full metal jacket could pass through his target. And he's really showing utter disregard for anyone in the line of fire as he fires 4 shots, including Mr. McGinnis. There's also bystanders. There's a house directly behind Mr. McGinnis. So I believe in firing 4 shots in a somewhat, I would say, wild manner. He is showing that there could be an argument that he says he didn't. I believe, again, that it's utter disregard, but a jury could find, because he did not know Mr. McGinnis was there, that he was not showing utter disregard for Mr. McGinnis's life, and that the second-degree endangerment would be more appropriate.
Defense?
Just give me 1 second here, Judge. Because it stems from, and tell me if I'm wrong on this, because it stems from the actions involving Mr. Rosenbaum, which this court believes the proper instruction deals with the utter disregard for human life of Mr. Rosenbaum. Those actions, to me, are intertwined with the charge involving Mr. McGinnis.
No, I don't think so, because I think the instruction anticipates that he could have utter disregard for the life of Mr. Rosenbaum, but still be sufficiently aware to realize the risk to Mr. McGinnis, and then he, under the law, as I read it, he would have the obligation to exercise his conduct is in such a way as to minimize the risk to Mr. McGinnis, whether privileged or not. He would, even let's talk about his conduct being purposeful, even though it's not charged. If he intended to kill Mr. Rosenbaum, and whether he was justified in that or not, he's still required to execute his intentions in a way with the minimal, or to minimize the risk to Mr. McGinnis. So if, and that's a jury determination, I'm not suggesting I would want to be in that position, who would, but he would have to decide, well, I've got to kill this guy, but I've got to do it in such a way that I don't hit anybody else. That's really what the jury's being asked to determine. And there are instances that you could imagine where the person actually would have freedom of choice and a conviction could be appropriate. One might not expect that to happen under most self-defense circumstances, but although for an intentional, then he'd be guilty because he intended to kill someone else.
And here's my only argument is, I think the testimony was the bullet that has endangered McGinnis passed through Rosenbaum, right? That Rosenbaum was shot, there's 5 wounds with 4 shots, so he didn't miss. So the reason that I'm kind of hung up on the utter disregard for Rosenbaum is if he would have missed, I suppose, and you could say that shot was a wild shot.
But he was using steel-jacketed ammunition.
Bullets are bullets, Judge.
No. I'm picking at hairs because that's what we lawyers get paid to do. But and of course, if we were in the jury room, and we'd laugh at each other for the things that are being said. In the eyes of the jury, they could theoretically, like how many angels fit on the head of a pin, they could theoretically think, well, it does make a difference because he wasn't using expanding ammunition. He was using a full metal jacket, and he should have foreseen that it might have gone through and that it would endanger someone else.
The defendant also denied knowing he was there, so the jury could very easily...
He did indeed. That was my next point.
My only argument, Judge, was that if he's using utter disregard, or the jury believes there's utter disregard as it relates to Mr. Rosenbaum, the charge as it relates to Mr. McGinnis directly relates to the bullet that went through Mr. Rosenbaum's hand or head or whatever it is, right? So that's why I'm saying if it's that for Rosenbaum, it has to be the same for McGinnis, only because there's not a wild shot. He didn't miss. He wasn't spraying. Nobody's alleged anything like that.
You could say that in your argument, couldn't you?
If
I left this on their verdict and you had to argue it, you could say.
I certainly could.
Pardon me?
I said I could.
The evidence does show that he essentially missed the 3rd or 4th shot. There's a graze wound that then traveled who knows where, possibly towards Mr. McGinnis. So this is not as though all 4 bullets entered Mr. Rosenbaum. One skipped right by him and basically had a contact wound. And the defendant says he didn't think he was there. So a reasonable jury could find that how do you show utter disregard for Mr. McGinnis when the defendant claims he didn't even know he was there?
I'm going to think about this one. My inclination at this moment, to repeat my former statements that have caused some consternation, my bias would be in favor of submitting that verdict and giving this instruction. But if it shows up on your doorstep, your email doorstep tomorrow at some point, and it isn't in there, don't be terribly surprised. All right. Count 4.
So count 3 it's essentially the same issue, except obviously this time the defendant knew he was there. I'll essentially make my arguments that I believe firing 2 shots, missing, a reasonable jury could find that he was not showing utter disregard. He only fired twice instead of 4 times. He did not fire into the individual after already striking him twice, as he did with Mr. Rosenbaum. He did not continue to fire. So I believe the mere fact that he fired twice and did not hit a reasonable jury, and again, we believe that first degree is the most appropriate charge, but a reasonable jury could find that because he stopped firing, he was not showing utter disregard.
We are talking now about a jumpsuit? Jump kick.
I prefer blue hoodie man.
What do you call him?
Blue hoodie man.
Blue hoodie man?
He becomes jump kick man once he kicks him in the face.
No, types do.
Did you want to respond?
Yeah. It's the first time I've ever heard that missing someone when you're firing from point blank range means that you're not showing an utter disregard for human life. So he fires Judge, he's on top of him when he kicks him in the face, and you saw the shots. It is difficult to ascertain an argument that a jury would believe because he stopped shooting or missed from point blank range with an AR-15 that he wasn't showing utter disregard for human life. I don't think that's a logical argument. I think the appropriate instruction is 1345. They're either going to accept that it was self-defense in that or they're not. But to say point blank range, 2 shots on a man jumping on you, yeah, that might not show an utter disregard for human life because either he missed or he stopped. I don't buy that as logical, and I would ask that you just give 1345.
If his conduct, the standard for the lesser included, I think, is still there is ground in the evidence for acquittal on the greater and conviction on the lesser. The same set of facts. What's the difference between what you're charging and the lesser?
I've stated what I believe the difference is. My worry is that the defense, I've asked now a couple times if they're just going to agree that there's utter disregard, and they've not agreed to do that, is that they're going to get these instructions and then argue it in their closings, and then we are stuck. So I would like some sort of limitation.
Why wouldn't they argue in the closings what the instructions are?
That they will argue that there's not utter disregard. That they will argue the opposite of what they're saying now.
No, I'm not hearing that.
Well, then why not agree to it? If they are agreeing that there's
they'd be nuts. That's why. How would that be?
What's that?
They'd be nuts. Why in the world would they concede on an element like that?
Well, they're conceding it right now.
No, they're not. They're discussing it for purposes of whether or not the lesser included should be given. They're saying, they're not conceding all your evidence. They're saying it's hard to believe that this would constitute or not constitute utter disregard for human life. Let me repeat the question I just asked you. I don't think there's a dispute in the evidence as to this individual, Mr. Jump Kick Man. The video is claimed to depict that he kicked the accused in the head. That the accused turned and fired at him twice and missed. On what ground could they convict him of the lesser without having convicted him of the greater?
Well, I'll stand by the prior arguments of the defendant's own statements, and also I think it does make a difference that he shot 4 times at Mr. Rosenbaum after he was already crumpling to the ground. The fatal shot was as he was falling to the ground, and he stopped shooting at the man in the blue hoodie. And again, I think the first degree is the appropriate charge, but I think a reasonable jury can say, why did he stop firing? Why didn't he, fire at him as he went away? I feared he might come back and run at him. So I believe a reasonable jury could find that, and frankly, if the defense in their closing argument tries to quibble with the utter disregard, I don't know if there's precedent for it, but I think we're going to ask for lesser includeds after that, because we're going to ask for lesser includeds after that. If they're admitting here that there's no way a reasonable jury could find otherwise, if they're agreeing to that, that's one thing. But
well, if they're agreeing to that, then why are you asking for a lesser included?
Well, they're not agreeing to it.
But I understand. I actually do understand what you're saying, I think. But let's do it again. Let's talk about the incident involving Jump Kick Man. What he was doing, what the defendant was doing, firing a gun at a human being.
Yes.
He hasn't alleged that he wasn't firing at him. He wasn't saying I was just trying to scare him off with a couple of shots across his bow. He didn't say that. Why he was engaged in it, and he's given his reasons, and I don't think the state disputes them. He was doing it to prevent the man from attacking him, and the state says the man had the right to attack him, and the defense said he didn't. Either way, he was doing it for what he was doing. It was purposeful. How dangerous was the conduct? Well, the defense is not disputing it wasn't dangerous behavior. I don't think they're going to argue that. How obvious was the danger?
The defendant denied that it was obviously dangerous. He said he did not know if it was going to kill him. He did not know that he denied knowing or that his bullets were more dangerous than other types of bullets. He denied knowing that his gun was more powerful than other guns. So again, I think the evidence most.
I don't think that is exactly what was stated. For example, the discussion about what kind of guns are more powerful. That wasn't actually it. I was kind of intrigued about it because it was a close contact, and the suggestion was being made by the questioner, Mr. Binger, that the rifle is because it's a more powerful weapon was more dangerous or something to that effect. And of course, in a close contact situation like that, it may be that the pistol is a much more desirable weapon. But I thought that discussion was focused on that type of issue rather than your claim that the defendant was suggesting his weapon wasn't dangerous? That it wasn't obvious? The danger wasn't obvious?
Judge, in his testimony, the defendant said, essentially, I was in fear for my life, but I didn't mean to kill him.
Is that what he said, or did he, when he was asked, did he mean to kill him, he said, I was just trying to defend my life, or words to that effect?
He said, I did not want to kill them.
Did he? I don't remember. Mr. Binger says yes. Mr. Krause says yes.
He said,
I think that's fair. At some point or another, he did say he didn't want to kill anybody. That's true.
That night.
But that's not the element. If we're a first degree, then that'd be another matter. This is reckless endangerment.
We're talking about the defendant's mind and if he had utter disregard.
No, we're talking about how obvious was the danger.
We agree. The state, under their evidence, has shown utter disregard. What we're fighting about is that it's not.
I'm still struggling with what is the basis upon which the jury could acquit of the greater and convict of the lesser, because that's the standard.
If they believe the defendant, they have a basis for the lesser included. There is a basis. If they accept the defendant's testimony,
I didn't want to kill anyone?
That I didn't want to kill anyone, that he bought the gun because it was
That
cool.
would be that. I might even buy into that. I might. Except that that would be if we were talking about a charge of count. Four. Because intending to kill is not an element of this crime.
But it shows whether or not he utter disregard if he's firing and not considering.
You're getting to the ultimate fact. I'm telling you what the factors are and determining whether there's utter disregard, and you're telling me that one of the factors to be considered on whether it's utter disregard is utter disregard. That doesn't make any sense.
Well, like I said, I believe the defendant's testimony gives a reasonable jury a basis to find a second degree.
I don't. So I will not give that instruction or submit that verdict. And the reason is because I do not feel there is a basis in the evidence for acquittal on the greater and conviction on the lesser. Count 4, number 2. You're asking for 1017, which is you're asking for 3 lessers. First, you're asking for first degree intentional. You're asking for second degree intentional, or first degree reckless, or second degree reckless.
Yes.
So now give me the bases for acquittal on each of the greater crimes and conviction of the lesser.
Well, with first degree intentional homicide, obviously there's a self-defense. The jury can find imperfect self-defense and find second degree intentional homicide. That if he did not reasonably believe the force, if it was not reasonable for the amount of force used. The defendant, again, while testifying, said he did not mean to kill Mr. Huber. So they could find from that alone that there is not an intent at all and go to the first degree reckless. And then we're left with the argument that we've been having all morning thus far, which is whether a second degree reckless showing utter disregard would be appropriate. The defendant said he didn't mean to kill him. The defendant gave his reasons why he thought he had to shoot him. But again, I believe he indicated he denied that he knew it would kill him. And essentially it's the same argument that's been being made all morning. But I think it's quite clear that in a self-defense case, second degree intentional is appropriate because the jury could very easily find in this case that it was not perfect self-defense. As a person who is running at him, being told or perhaps even witnessing himself that the defendant has already shot someone and gravely injured them, has already shot at another person missing, and then gone in to try and disarm him, the jury could find that it was not perfect self-defense.
Are you disputing that?
No, first and second.
First and second,
No.
intentional or okay?
Yeah.
Okay. So then the reckless, the defendant testified directly that he did not intend to kill him.
Any dispute as first degree reckless?
No.
Okay. All right, any objection to second degree reckless?
For the exact same reasons that we had talked about, Mr. Huber, I'm sorry, Judge, if you already...
No, that's all right.
Mr. Huber has the evidence was a rifle pointed up against his chest.
I didn't hear you.
He has a rifle, according to the evidence, he has a rifle pointed literally up against his chest. So the idea, under those circumstances, that having an AR-15 pointed up, buttressing up against your chest would not be utter disregard for human life if believed, to me that's where it begins and ends. There is no other explanation. So I think first degree, second degree lesser included, first degree reckless are all appropriate. Second degree reckless doesn't fit.
Did you want to respond?
I'll just stand on my arguments before. This afternoon, we may review the defendant's testimony, and if I find a specific thing that I think changes it, will obviously contact the parties.
Okay. I embrace the argument of Mr. Sharafsi. Then count 5, you are, and that is the shooting of Mr. Grosskreutz, and that is charged as intent to kill?
Correct.
Okay.
So the instruction I requested is attempted first and then attempted second for very much the same reasons as Mr. Huber, that a reasonable jury could find imperfect self-defense, as Mr. Grosskreutz was actually facing away from the defendant when he fired. And then the next lesser included, if they don't find intent, is the first-degree reckless endangerment. So I've requested that, and then obviously I've requested secondary reckless endangerment, which we've rehashed a few times now.
Defense?
Judge, I don't have an objection to the lesser included on the second-degree attempt. It's the same argument. The court heard the evidence. In the distance, Mr. Grosskreutz testified that he was about 3 feet away, whatever it was, from him when he was shot. The gun, Mr. Grosskreutz pointed the gun at the defendant. Mr. Rittenhouse then fired. So I think that attempted first degree, well, you can't attempt a reckless act, right?
I would have told you, I would have agreed with you some years ago, but I'm not sure. I don't know the answer, and I certainly am going to have to hit the books on that. That was certainly once the law.
I would have, you either are, to me, you're either reckless or you're not reckless. So I would object to any recklessness because I don't think you can attempt a reckless act. So I'll leave it at that and let the court ponder that.
Well, the defendant did testify that he didn't want to kill anyone.
I understand that. But I think somebody would say the behavior is either reckless or it's not. I don't know how you can attempt to be reckless or attempt to be negligent. I don't know how you can do those things.
Judge, if I may respond, I mean, we just basically agreed on the comment by Mr. Huber that reckless homicide was appropriate. Mr. Grosskreutz did not die, so the appropriate charge at this point would be the first-degree recklessly endangering safety. The jury could easily find that the defendant intentionally shot Mr. Grosskreutz, which is not, I guess, in dispute, but that he did not mean to kill him. The defendant said multiple times, "I did not want to kill anyone." The jury could also find that shooting someone in the arm, if they find that was where the defendant was aiming, would not be intent to kill, but it would be recklessly endangering his safety. If the jury does not obviously find that it was perfect self-defense.
Is it a lesser included?
Yes.
Statutorily?
Yes.
Yeah, I think you're right. Because otherwise, why couldn't they convict him of both? But why get into a discussion we don't need to resolve? We'll have it. We'll do it later. Okay. I don't know. I'm going to think about this one. I'm inclined to agree with Mr. Krause. Okay.
On count 6, we are not requesting any recklessly endangering safety charges, so we can skip that argument.
Bless your soul. Now, the defense has submitted, and I don't think you submitted anything standard, except standard on that.
Our position is they've never raised the affirmative defense. So that's why we need to do it.
At the trial.
Correct.
Let's see.
And obviously they can argue otherwise, but that's why we did not prepare one. Obviously they can argue otherwise, but that's why we did not prepare one.
I don't recall any evidence, correct me if I'm wrong, as to the third element of the second defensive matter which you cite on the second page, on the third page. Item number 3 on the third page. I don't recall that evidence.
I would agree there was no evidence that he...
Then how can I give that instruction? Oh, because they have the burden of proof.
It's not a strict liability offense.
Yeah,
He's 17 years old.
Yeah, if there's an absence in the evidence, that's kind of a problem for you, no?
What do you mean?
You would need to disprove the affirmative defense.
We don't believe it was ever raised. They never gave any evidence as to barrel lengths or that it
Oh yes, there was definitely barrel length evidence.
On cross-examination of a state's witness.
Whenever it happened, it was there.
And
Well,
was,
now I'm not sure. There was evidence of the length. He had the ruler out and he had measured the length of the portal. That
I asked Detective Antranian.
did you?
Yep.
Assuming that to be true, then that would then that was less than. Excuse me. It was the barrel length was greater than 16 inches.
Sorry.
Wait a minute. Either the barrel length was less than 16th or the overall length was less than 26. That was in the evidence?
What I asked him was there any, did he believe, I want to make sure I have it right so I don't misstate it. Did he believe that the barrel length was in violation of the law?
What law? I mean, there may be, I don't know what laws there are.
The possession of a short-barrel shotgun or short-barrel rifle.
That's the only.
That's the law. You can't
Okay,
have a
you're
gun
talking
that's...
about, okay,
Yeah.
okay.
And that's built into
Okay,
this
well,
instruction.
he certainly, come on, it's not a strange issue to this case. I mean, we've been talking about it for months.
well, and I agree with you talking about it for months, and the defense should have measured the barrel in front of the jury and said the
You
barrel.
have the
length.
burden of proof.
That they didn't. If they raise it, they never raised this issue.
Well, did he ask the detective whether it was what was your question as you recall it? And this is going to be dependent upon what the actual evidence was. But what do you claim it was?
When he took the gun from the Antioch Police Department, did he believe that there was a violation of the law as it related to the barrel length?
That goes to his belief in what. And they never specify which law.
They have to raise the issue.
I understand, and I don't believe that they have. And there's no testimony on the authorization, the certificate of accomplishment to obtain authorization for hunting. There's no evidence on whether or not he has a certificate of accomplishment to obtain authorization for hunting, which is the state's position all along, is that he would have to have that.
Well, they're claiming it's in the alternative.
And the state has always claimed that it is not. So we're back at, well, if the court finds they raised it, which I don't believe asking a general question on the belief of a detective, that is not evidence, the belief of someone.
Well, is it a belief or an observation?
The way Attorney Trossi just said it was belief. We'd have to get the exact question, but I don't believe...
The exact question may become important.
So I don't believe that is raising it. And the defense had every opportunity. They brought the gun over here most every day the last few days. They could have gone over any number of witnesses to measure it and raise this issue, and they did not.
They don't have to measure it. That's the burden of proof it's on the state.
I understand that, but it wasn't raised. Is our
Well, if he asked the officer, and I will have to see what the transcript says, if he asked the detective whether the rifle was compliant, or what are you claiming you said?
I asked him if there was, I know I asked him about it. the question I asked, I think I asked him something along the lines of, did you believe there was any violation for the barrel length of the gun?
That would put it in issue if the question is like that.
Well, also the statute reads, this section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of section 941.28 or is not in compliance with the two sections mentioned. So it's an or, it's not an and. We don't have to show all three. So they may have raised the issue with...
You have to show one of the three. You have to show one of the three. No. What am I saying?
No, we have to show...
You have to show any of the three which the defense has put in issue.
So
the defendant has not put in issue the certificate of accomplishment.
Correct.
The defendant has put in issue the length of the barrel.
And, Judge, we can unpack this for a minute. So the exception says it's a violation of the law if you're under 18 and possess a short barrel shotgun or rifle. Okay? That's one way you can be convicted. And it says, or are in violation of Wisconsin statute, I think it's 29304. 29304 only applies to people 16 years of age or under.
Right.
There's been testimony that he's 17.
No.
Okay? So I've conceded, because he has to be in violation of both 29304 and 29593. I concede he's in violation of 29593. However, 29304, he's 17. It doesn't apply to him. It can't apply to him because of his age. We put in his age and we put in the barrel. That covers the first exception, and then it goes to or, and it covers the second exception as well. I provided the court, and I'm not rehashing it, that you had denied the motion for reconsideration. This statute doesn't apply to 16 and 17-year-olds, period. The legislative history that I provided to the court, it says it in black and white.
Well, I ruled as I did because the motion to dismiss attacks the complaint.
Understood.
And the complaint was adequately pled under the law. That was not an endorsement of the state's position on the case. And to use a trite expression, the rubber hits the road here at the trial. So now you have to prove everything that the statute requires. And do you dispute the fact that you need to prove that the defendant was under 18 at the time of the incident? You don't. That's not in dispute.
that he's under 18, yes.
And that the barrel length was less than that allowed by law, or was not within the range permitted by law.
We don't have to prove that.
You don't have to prove that.
But it's or. I mean, there's no real. Our argument is that they did not raise it. I don't think it's really a disputed fact, but we believe they did not properly raise this first part of the exception. The second part of the exception, they've conceded 29.5.
Go ahead. I'm sorry.
They've conceded the 29.593 portion. He did not have a hunting certificate. So then we go to 29.304, and if it is allowed that simply being 17, he is in compliance with that, it swallows the whole statute, and the statute makes no sense. So if the statute
makes no sense, you're out of luck.
Well, if the statute is valid, it's clear as day that it says a person under 18
clear
years
as
of age.
day. I would not say that about this law.
Well, I would maybe not say that about the exception, but the actual law, 2A, is quite clear.
It is.
Sure. Any person under 18 years of age who possesses or goes armed with
that's
a
not the whole
dangerous
statute. That's not the whole statute.
Our position is that he is not in compliance with 29.304 and 29.593. I know that this was scoffed at when I mentioned it before, but 16 and 17-year-olds can hunt alone in this state if they have the correct certificate.
Okay.
Under 16 cannot, and that is what 29.304 is addressing. This statute is addressing hunting.
No, the basic law is that the rubric is not part of the statute.
The rubric?
The title.
The title is possession of a dangerous weapon by a person under 18.
It's not part of the statute. No, I learned it in an
That's
earlier
what the
time when we called it the rubric.
That's what the statute says, though. That's what it says in 2A. And the state's position is that he is not in compliance with those two, and that they have not raised the short barrel shotgun issue.
The what?
The short barrel shotgun issue, but they don't really have to because they can try to raise the other part, but they have not done that either.
By his age, it's raised. On the second part. It's raised.
Yeah, that's true.
So that's it. And I just want to make sure I've been losing this argument. It's not, Judge, there are hunting portions of that statute, and there are just simple possession portions of that statute, of 29.304. I am not focusing, and I'm asking that it doesn't apply, the hunting part. If you read the Legislative Bureau, what it says is, if you're 16 or 17, there is an exception for you to possess a firearm.
It does say that.
Semicolon, done. It has nothing to do with hunting. Nothing.
My inclination now, once again, I'll tell you what I'm inclined to do, is to inform the jury let's see.
Judge, may I respond to Attorney Sharofsky?
Yes.
Legislative history only becomes an issue when there's ambiguity. There's no ambiguity in 2A. It is very clear that 18-year-olds are not to possess dangerous weapons. So you interpret the statute in a way that makes sense. And the way that it makes sense is that simply because he's 17 does not automatically negate 2A.
Well, I raised it earlier in the case, and it hasn't enjoyed a lot of discussion, and maybe I'm off the wall. I don't think so. The penal laws are construed strictly. Vague laws are, who is that emperor from way back in history who posted the laws on pillars so high that the people couldn't read them? And that's been used by lawyers and judges for centuries about the requirement that people be given knowledge of what the law provides. And the basic law, and it's chipped away a lot of times with the appellate court decisions that are made on the subject in efforts to preserve the statutes, because some of them are quite messy. And that's not a criticism, that's a reality that judges have to deal with periodically. Most of the statutes are easily enough worked with. But the basic rule is that the ordinary people should be able to understand what their laws are, so they know what conduct is allowed and what isn't. And I've been wrestling with this, and now I know that there's a lot brighter judges in this world than me, but I've been wrestling with this statute for, I'd hate to count the hours that I've put into it. I'm still trying to figure out what it says, what is prohibited. Now, I have the good fortune of having some experience and a legal education. How is the ordinary citizen supposed to acquaint herself with what this law says?
Judge, there's testimony that the defendant, Mr. Black's stepfather, the defendant's mother, all knew he could not legally possess this gun. That's why it was kept up here. That's why Mr. Black bought it. This 2A is very clear.
For interpreting a penal statute?
I'm sorry?
Is that the standard by which the judges interpret a penal statute?
You just said it should be clear to normal everyday people, and it was clear to these normal everyday people. Because it's very clear that under 18 cannot possess a dangerous weapon.
They don't know the law. And he can't necessarily possess the gun in Illinois. We're talking about Wisconsin, and we're talking about the law, not what Dominic Black's father might think.
Obviously, we're responding to your...
Well, but the point is, you know, if they put a sign out here, don't jaywalk over to the other side of the street. And that's a bad example because we know jaywalking is unlawful. Supposing they put a sign out there that said, don't use your cell phone while crossing the street. Now, if they adopt a law that says that, and people are, not, as I told the jury before, ignorance of the criminal law is not an excuse, so people are charged to know that, unless it's written on the top of a pillar so high people can't see. People, if they're given legal notice, that's why they publish them in the newspaper. If people are given legal notice of what's unlawful, then they can conform their conduct to the requirements of the law. If they don't know what the law is, then they're just herded into obedience of certain standards. Now, I don't know if that's the case with Dominic Black's stepfather or father or whatever it was, or the defendant's father or whatever. Whether they studied the law, they were familiar with what it says, or they were just afraid to break the law because they heard somewhere along the line that it was unlawful. Well, I'm not allowed to do that. I'm not allowed to say, well, they should have guessed right. I can tell you I've put many hours into it, so have you. And how are ordinary people not supposed to know what they should be afraid might be against the law? How are ordinary people supposed to know what's against the law?
Because 2A is very clear.
Wish it were to me. I'm going to my intention is to instruct on what he's submitted, without page numbers, I might add. Looks like the third page that starts statutory definition of crime, and down to where it says or. So it'll be exception, the state must prove, etc. Then number 1, the defendant was under 18. Number 2, and that the dangerous weapon was either a rifle, etc. And you can search the evidence to find out if you can prove beyond a reasonable doubt that that's true, so that it can go to the jury. All right, now, is that it?
The state requested the 805, 810, and 815, as well as 9.
Any dispute as to those?
805, no.
Okay.
810 and 815 are the retreat and provocation instructions, so yes.
Okay, go ahead.
Well, I guess I would ask this first, Judge. As it relates to 815, which is the provocation instruction, is the state saying the presence of Mr. Rittenhouse there is in and of itself provocation?
No, we are saying that in the incident of Mr. Rosenbaum, he provoked it by raising his rifle and pointing it at individuals. So that is why Mr. Rosenbaum then gave chase to him. The defendant then had a duty to retreat. He retreated. Instead of giving notice of his withdrawal from the fight, he turned and pointed his gun again at Mr. Rosenbaum, an unarmed civilian, which he admitted he knew he was unarmed, and that continued. So no, the provocation is not his mere presence. It's not his mere presence with a gun. We will argue that the video evidence, contrary to the defendant's testimony, shows that he raised his weapon at individuals, and that is what provoked the attack. By Mr. Rosenbaum.
So, Judge, yesterday, obviously you know why we were fighting about what that enlarged photo, and I don't think that's what I think that evidence is open to interpretation, certainly. I would argue to the court that while Mr. Kraus can say that's what they believe it shows, I would submit to you that what the testimony is Mr. Rittenhouse is shortly before that yelling, "Friendly, friendly, friendly." I think if you look at that picture that you saw yesterday, it's open to interpretation. We know he's wearing a strap from the harness over his shoulder. The other thing that if you look at the picture closely, he's standing like he would be firing or pointing that gun like he's left-handed. So if you look at the picture, his left foot is back, his right foot is forward, and he's open like you're looking at me now. So in every other instance where you observed a gun being fired, he's firing it from the right side with his strap as his gun hangs this way. Now they're saying that that photo shows that he was standing and picking the gun up and doing it left-handed. I think that photo is open to interpretation as to what it is. We believe that it shows a side mirror of the Duramax and part of his strap from his firearm, or from his sling. That's open to interpretation. I completely understand that. However, you also heard testimony that from this person from the State Crime Lab, who said he couldn't really answer, and I don't know what you thought of his testimony yesterday, but he really couldn't answer a lot of questions on, and that's why color was so important yesterday, on how the pixels work, and he couldn't say what color those pixels add, and I think that's relevant. Now, it is our position, and I think the testimony supports the idea that Mr. Rosenbaum provoked the attack.
That Mr.
Rosenbaum provoked the attack. Mr. Rosenbaum, there's testimony from two people that Mr. Rosenbaum threatened to kill Mr. Rittenhouse if he caught him alone. You heard the testimony that Mr. Rosenbaum yelled, "Gun, gun, gun," and then you know what was said after that. He's chasing him down. He yells, there's been testimony that Mr. Rosenbaum yells, "F you," before this happens. Mr. Rosenbaum has a gun pointed at him in the parking lot and doesn't stop running toward Mr. Rittenhouse. And if you give 815, which is the provocation instruction, I would submit to you the only way that Mr. Rittenhouse then can be acquitted or found not guilty of the charge is, one, he exhausts every other reasonable means of escape. Two, he withdraws from the fight, and fight is the language in the instruction. And three, he provides, sorry.
Well, go ahead, finish, and then I'm going to tell you why I don't agree with what you're saying.
Okay. Well, I'm looking at 815, but
I'll interrupt you now and tell you.
Okay.
You said if I give that instruction,
Yes.
then the only way. No, the jury may not believe the predicate facts upon which the instruction is based. So he could be acquitted as long as the jury does not believe that the defendant's behavior was provocative.
That's the first line of the instruction.
Say that again?
That's the first line of the instruction.
What?
You should also consider whether the defendant provoked the attack. The defense is still able to give forward their version of events. We have multiple videos in addition to this photograph, and also a defense exhibit number 41, which has it circled on there where the defendant is raising the gun at someone in front of that Duramax. That's an exhibit they have gotten into evidence. So there really wasn't much dispute of this until a few days ago, and that's fine. They can dispute this fact. We believe it's very clear on video that the picture itself is just one little portion, but on that drone video, both the full version and the somewhat zoomed-in version that has been provided, it's very clear. I saw it on my television at home immediately upon watching it. So that's our argument, is that he provoked it by doing that. Now, as the court has pointed out, This is not forcing the jury that there's it's not forcing their hand. They don't have to find provocation. You should also consider whether the defendant provoked the attack. And that is a consideration, and that is a point of contention in this case. And I believe it's an appropriate instruction for both incidents.
Judge, the last
I
thing,
interrupted you.
No, that's okay. The last thing that I was going to say is it would also require that he give Mr. Rosenbaum adequate notice that he is withdrawing from the fight or the attack. I think under those circumstances that's impossible to do. But more importantly, I have found a case, it's from Kenosha, on provocation and what that means in terms of a self-defense. That is State versus, and I'll just spell it, it's Boughnet.
Can you spell one more time, please?
Boughnet. It's at 97 West 2nd, 687. And in that case, there was a gentleman in a diner, and people walked into the diner, and he started to harass them. He tried to grab the women, harassing the women, verbally accosting people. And one of the men that the women were with came over and said, "You need to apologize." The defendant said, "Let's go outside." So they go outside. The defendant ends up going to his car, picking up a shotgun and shooting the man in the face. And the argument was, did he provoke this? Now, there was testimony to everything that I just told you. Did he provoke that by starting the fight, sexually harassing the women, using the language he used, and then ask the guy to come outside? And the court said he did. So the provocation instruction is clearly appropriate. I don't believe there's sufficient evidence in this record to support the idea that Mr. Rittenhouse provoked this attack. I don't think that that's there. So I understand that it doesn't require that they follow that and say, well, he did provoke it, but I think there has to be evidence to support that. And I don't think that photograph in and of itself, which is obviously open to interpretation, supports the idea that they have to or should consider whether or not that was provocation at that point.
May I respond? I agree the photograph alone would not give the basis for provocation. The photograph is the last piece of evidence that was submitted on this. Detective Venturini testified to it. We have pointed it out on videos. We pointed out to the defendant on the video, and he gave what I believe to be a lame explanation for it. And again, the defense's own exhibit has it circled on there as it happening. So I believe there's plenty of evidence that Mr. Rittenhouse did raise this rifle and pointed at someone off in the distance, actually Mr. Zeminski. And let's not forget also, I've not given my full argument on provocation yet, the FBI video. Well, let me go back. The Corey Elijah and the Drew Hernandez, actually Frank Hernandez videos, shows the defendant walking behind Rosenbaum, Mr. Rosenbaum, on the way to this car source area. At some point, Mr. Rosenbaum begins running. We see that on the FBI plane footage. Our argument is that Mr. Rittenhouse then begins running and following Mr. Rosenbaum. That he follows, if not the whole way from the Ultimate gas station, then Mr. Rosenbaum starts running. That provokes the defendant, who is actually very slowly and casually walking for quite some time, seemingly, to then go and follow Mr. Rosenbaum there. He then, and the defense's argument is that this is some sort of ambush. And I don't know how you ambush someone that you don't know they're there, but we'll put that aside.
What?
I don't know how you ambush someone you don't know is coming, but we're going to put that aside. So the defendant runs onto the scene and then is seen by testimony and video evidence gently putting the fire extinguisher down. He says he dropped it, but he places it on the ground and he raises the gun, and I disagree about the left-handed thing that Attorney Trofsky just said, and raises it at Mr. Zeminski. That is all in evidence. It's in a defense exhibit.
Can I see that? Is that readily available? Bear with me 1 second.
The state's position is that the running after Mr. Rosenbaum probably in itself was enough to provoke the attack, but putting that aside, certainly raising a gun and with no basis for any kind of self-defense. There's no one around him at the time except an individual in a wheelchair who's behind him. He raises his gun, I would guess, because he thinks there's vandalism going on, but we don't know that because the defendant denied that he did it. And then Mr. Rosenbaum approaches, he somewhat drops the weapon, he keeps two hands on it, and then he has a duty to retreat at that point under provocation, and then he runs. I understand why this instruction is problematic for the defense and for their version of events, but that does not change the fact that pointing a gun, which is in the evidence, is provocation. The defense is
well, wait a minute, no.
Attorney Trofsky informed me I was looking at the writing. I'm sorry.
Well, you will see if you can find it.
I misunderstood.
Which exhibit are you talking about?
Talking about the compilation video that the defense put into evidence, I believe it's 41.
I have it on my screen right now on my computer, Your Honor.
Then you said, we'll see if you can match it up with what she's looking at. Then you said that something about the one person running after another was provocation. Well, how is that provocation? We're talking now about you're alleging that the defendant was running behind Mr. Rosenbaum, and that was provocative?
That he chased him there.
Your Honor, you can talk all about the evidence. He's walking, especially the video that was put in yesterday through Mr. Hernandez.
Yeah.
He's walking within steps. Rosenbaum and Zeminski are lighting the garbage can on fire. He sees my client walking down the street with a fire extinguisher, and there's fires down at Car Source. Mr. Rosenbaum knows where he's going. He's already threatened to kill him. He sees him coming. He's got very distinct purple gloves. He goes down and he lies in wait. There's no chasing going on whatsoever.
Where's the chasing? And where is the chasing, and how is that provocation?
The provocation is the raising of the gun.
Oh, so, because a moment ago you said that the chasing was provocation,
I believe it
which of course it could be.
I believe it adds
if it's
to
in the evidence.
I'm sorry. I believe it adds to the provocation that he chased him there and then immediately raised the gun.
He wants the instruction, and then he's going to argue what he just said 5 minutes ago.
Well, and we're free to argue that.
Just like we're free not to stipulate to the third element.
What am I looking at? There's a circle.
I don't believe it's playing yet.
Show me with the pointer what you're talking about.
I'm just pointing out that this indicates he's pointing a weapon.
Huh?
I'm just pointing out that this defense exhibit indicates he's pointing a weapon. We have much clearer video showing this.
And it still has Rosenbaum behind Rittenhouse, if that's Rittenhouse. I'm going to just step out for 1 second. I'll be right back.
We'll take a minute. You would have the burden to prove beyond a reasonable doubt the accuracy of what you're saying. You have to disprove the defense, but Yeah,
The defense, are we back on?
go ahead.
The defense's position is that Rosenbaum was yelling gun, gun, gun. Why do you think he was yelling gun, gun, gun? Because Mr. Rittenhouse had a gun. Now, I mean,
Oh, go ahead. I'm not trying to interrupt you.
yeah, the court is exactly right. We would have to prove this. We have testimony, video, and photographic evidence of this occurring. It is our burden to prove it. I agree. But the jury should be given the instruction that they should consider it. Because if he raised this gun, it's clear provocation. So it's up to us to present the proof, which obviously will be a central piece of our closing argument, with the, I think, 3 different videos, this defense exhibit, which at least indicates that it's there, and the testimony of Detective Antaramian, who indicated he saw this, I believe, after cross-examination or on cross-examination. And the jury can decide it. We don't have to prove it beyond a reasonable doubt to the court or to the defense right now. We have to prove it beyond a reasonable doubt to the jury on Monday. There is plenty of evidence in the record to indicate that, to give this instruction. I understand it's problematic for the defense. I understand it's problematic for their entire theory of the case that they presented in their opening. But that doesn't mean that we shouldn't get it, because we have presented evidence of this provocation, that the unlawful conduct provoked Mr. Rosenbaum to attack him. If the jury buys our argument beyond reasonable doubt, fine. If they don't, that's their prerogative. They're the fact finders, not the people in this room. We have presented facts for them to consider. They should be given the opportunity to consider those facts in this light.
Judge, I don't think that photograph, maybe I'm wrong, shows anything.
Well, that's for the jury, though.
I understand, but they're asking out of that photograph to give a provocation instruction.
No. We're saying
There's no other evidence.
We're saying that
No, just a minute.
There's no other evidence. We've talked about the chase thing, right? But every other thing that's come up about what Detective Antaramian said, what anybody else has said, comes from that photograph. That's it.
No, it comes from the drone video, and the defense attorney, the defense knows this, which is why they've fought so hard to keep this out. This is not some new revelation. It's in the police reports. There are allegations that he pointed this gun. This is only to demonstrate that a defense exhibit indicates it. We're not using this to prove it. We're using it to show that even the defense exhibit indicates that this is there. We have testimony, we have video evidence, we have, I believe, photographic evidence that helps, but to say that we're basing it on a blurry photograph is completely dishonest. They've seen this video and they know what's on it, and they know it is problematic for their defense.
I can't rely on what you think they think.
I understand. I'll change my argument. But the simple argument is there's plenty of evidence that the state has provided that he raised his gun. It was a known part of the discovery in this case. We should be able to argue that, and we would argue provocation, so the jury should consider it. And they clearly, as they pointed out in their evidence and their opening and their argument today, they can rebut that and indicate we have not proven it. And that's up to the jury. That is not up to us. So I believe we should give the instruction is appropriate. It's add the following when supported by the evidence, and it is supported by the evidence.
There's been no secret about my lack of technical awareness in the trial here, and I thought of it. I decided not to intervene yesterday. I did ask Mr. Armstrong some questions to try to better understand what was coming off, but I didn't go further into it, in spite of a temptation to do so. When I get messages from some of my friends, my few remaining friends, they come as texts, and then they start belittling me or whatever in one way or another, and it can be quite lengthy, the exchange that's going on between them and us, but they're entertaining, and so I don't know how to save text messages. I haven't figured that out, and I have a lot of things that I'm doing, so that's a low priority for me to figure out how to save a text message, and I don't want to leave them on my phone forever. I want it off so that it's clean, so when I look at it, I'm looking just at the fresh stuff. So then I do a screenshot of it, and I email it to myself to save it. But I found, to my distress, that some of them are pretty long, and they show up in my email like this, like a little ribbon down the center of the page. Some of them are even smaller than this. Well, then I go to open them up, and it's just a blur. You were talking the other day, one of you two, about it's just like a cell phone where you can expand a picture and make it bigger. Well, it's not making it any bigger. It's making it bigger, but it's nothing but a blur. That was my concern that I wanted to ask Mr. Armstrong about, and I guess I should have, for him to explain it better for me as to how that can be reliable. Because it isn't reliable for me in getting my messages on my phone. Now, maybe if I reset it to a site, I could explode it again or decrease its size again, and I don't know. But here you've got a picture, which I have to tell you, I think it's very blurry.
I agree. And the picture is one of 5 or 6 pieces of evidence. So I know the defense wants to focus on this picture, but the picture is only one. We have 3 videos, one unedited, completely untouched drone video, which I think is where you see it the clearest. And then we have one that is zoomed in, and we have one that is slowed down. I believe the clearest shot is actually the original drone video. So we can present that evidence, and they can rebut it. I think you're taking the picture wrong on your phone. I'm not tech support.
Pardon me?
I think you're taking the picture wrong on your phone.
Is that it?
I think so.
I'm not surprised.
But these things are in evidence. You watched it on the screen yesterday, whether you formed your own opinion or not, and that was
my opinion is not what counts, except to the extent that if there's if it's just totally unclear, then I certainly can't give a provocation instruction based upon a picture that I can't make anything out of. I agree with you. The ultimate determination of what it shows is for the jury.
It is not based on
you have to be over the threshold.
It's absolutely not based on the picture. It is based on the drone video and the testimony. And this was testimony elicited, if not by the defense, then in response to their questioning. Detective Antaramian testified he reviewed it and saw it, and that was a common question to many people in this case. The photo is like the 5th or 6th most important piece of evidence. The most important piece of evidence on this point is the drone video itself, and that is unedited. There are some edited copies as well that are helpful, but to focus on this photograph, that was almost an afterthought simply because we didn't get it till the day before, and we figured it may be helpful at some point. The photograph is, we may not even show that to the jury. It is based on the drone video and the testimony of Detective Antaramian. It is in the record. We have evidence of provocation. I can't fathom why, if there's evidence in there of provocation, which we have clearly done, why we cannot argue it and why we cannot get that instruction. The defense is free to completely call it whatever they want and to attack it. But that is why we have trials.
I haven't seen it clearly, okay?
I have.
Oh.
Your Honor, they're arguing for something saying we've been on notice from the beginning. And if they wanted to put on the evidence to prove up provocation, all they had to do was call Mr. Zeminski or Mrs. Zeminski to rebut the story that we have. They didn't put him on because Detective Antaramian, Detective Howard both know he's a liar. And they're building their whole prosecution on that without putting them on.
Well, they don't have to call a particular witness.
But they don't have the provocation. And, you know, we had all these little things going on yesterday, and I went back to my office, and the whole essence of the problem came down to these two facts in the testimony. Examiner Armstrong took 20 hours to manipulate that photograph to get that blurry mess up on the screen. We had our expert do it right in front of the jury in seconds, and it showed what it was. And that's where the hocus pocus and adding the pixels and all the other garbage comes in, and that's what they're building their prosecution on.
Again, we're focusing on a picture that is again, we're focusing on a picture that I have said repeatedly now is the least
Well, show me the best
convincing.
one.
What?
Show me the best one.
Your Honor, yesterday, before Mr. Armstrong was allowed to testify in rebuttal, we went over this about whether or not the methods he was using were appropriate, and we showed you walked up to the 4K
Yeah.
TV, and we showed you exactly what it is we're talking
And
about.
I'm not even going to tell you what I thought when I saw it.
And Judge, this is not a court trial. You're not the finder of fact. We have facts.
I know it, and that's why I let it go to the jury.
We have.
So we're asking.
That's what we're asking, is that the jury be allowed to consider the state's evidence, is essentially what we're asking.
I don't think, Your Honor, you would have allowed Mr. Armstrong to testify yesterday. I don't think you would have allowed him to testify in rebuttal unless you had made some determination that there was some basis for this.
What I made a determination was that I thought the jury should make the decision.
And that's all we're asking.
So that's your best picture, the one I saw over there?
No.
Where's the best picture, please?
That we'll show it to the finder of fact.
You're asking me to give an instruction. I want to see the best picture.
It's the
We need to get Mr. Stute over here, I think.
we need it on the big TVs.
You need it on the big TV?
Are you talking
All
about
right,
82?
bring it up if you would.
What is that?
82 is the slow
No, I think the best picture is on the original drone or the normal speed one.
73. You say so.
Judge, I think using the defense, we've got the exhibits on our one of our laptops that I think Mr. Stute has. I've texted him to come on over, but I think Ms. Wisco is graciously going to be able to play them for you. I would recommend watching them on the 4K TV. I think that's the best way to see them. So we can set that up. There is the full drone footage. There is the slowed down drone footage. And then, of course, we have the photographs that Mr. Armstrong had yesterday. So. Yeah. Judge, again, I would recommend, like yesterday, coming and watching it on 4K TV, which has pixels. If it's
it's not 4K quality.
What's that?
I said, this TV,
It's your TV.
adds pixels to something unless it's 4K quality. It does
Where's
next
the
to
evidence on
nothing.
that?
It's your
It's
TV.
common sense and judgment, Jim.
There's no evidence on that.
Are you saying I'm lying?
I have no idea.
I'm saying there's no evidence on that.
I'm asking.
But you
I'm
gave
saying
me
there's no
another,
evidence.
Well, it's common
Questionable argument.
sense.
You brought in this TV to show the exhibits. You
Yeah,
brought in the
4K
TV.
drone.
You brought in the TV to show the exhibits. So that's what we're doing.
Yeah, I'm gonna take my choice on this.
You want us to use Mr. Marciano's pointer to show you exactly where we're...
Something's up there.
Okay, I'll
Just
grab
use
it.
your hand. Okay.
This is the unedited.
Okay.
Is this unedited?
Yeah, this is the unedited.
73.
So Judge, we're going to be focusing your attention right here at the base of this
Right.
sign. Okay, that's where the defendant is going to come into. Go ahead. Okay, you can stop because we're past it now. Okay, I don't think this is the same quality as our version, is it? Yeah.
Our version is much clearer.
Yeah. We'll have to get our...
I have the enhanced one, I can play as well, but that is exactly what we got from you. I downloaded it straight from Dropbox.
Yeah, Mr. Stutz coming
So
up.
what you're showing me now is, this doesn't show anything. This is
Got-
what was provided to the defense?
Yes.
Mr. Stutz on his way. Here?
I downloaded that straight off Dropbox. So if your version's clear, that means that you didn't give us your version.
It's just plain weird.
That's not how that works.
Is this the zoomed in or the regular?
This is the regular version.
So we're looking right here. This is the defendant. He puts it down and he raises it up right there. He has it pointed until Rosenbaum approaches, then he runs around.
Try it again, please.
Play it
Try
again, please.
And can you slow it down?
We have a slow.
Not in this version. We have a different version of this.
That's what you watched yesterday.
Go ahead, sir.
Right here is the gun. Right there is the gun right here. Oh, wait, no. It looks very similar to that when he points it here, Mr. Rosenbaum.
One more time.
Here, Stu, let me pause it 1 second in, please.
Start playing.
Pause.
Pause.
Right here. If you watch it, when he goes right up here, he puts the fire extinguisher down gently. It topples over, and then he immediately raises up like this. And the gun is right, we argue, right here. And he stays in this position like this until you see Mr. Rosenbaum come around. So Mr. Rosenbaum, if he is yelling gun, 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 we would argue it's to warn all these people that he is pointing a gun at them, and that he is chasing him out of the area to avoid danger. But if you see right here, the state believes, with all the motions taken, that's the gun. And here's it's right here.
Is that where Mr. Rosenbaum yells, "You're not going to do shit, MFer"?
We can talk about this on closings, if you want.
I was just curious.
What's that?
I said I was just
All right.
curious.
All right.
So why don't you play it from the beginning one more time? You see him drop it right there as Mr. Rosenbaum approaches. Or lower it, I should say. Would you like the zoomed in or slowed down one?
I'd like to see the enhanced one now.
In normal speed or slow speed? Do the zoom in normal speed.
Zoomed in normal speed.
Do you need a number?
Yeah, I think it's 81 and then 82. Right. 81 first. Yeah, 81 first, then 82.
So this is slightly cropped and normal speed.
But the court reporter wants to use the wireless mic.
Oh, so this is the defendant right here. You can see the AR-15 is on his chest. The fire extinguisher you can't see right now. It's blocked by this man in the wheelchair. But you'll see him walk up again. He will gently place the fire extinguisher on the ground, although it will fall over, and then he will immediately raise his gun up and point it at the individuals who are over here, who I think are right now blocked by this street light. But they're the Zeninskis. Okay, go, Brian. See him lift it right there. He's holding it right there until Mr. Rosenbaum approaches. You see the very distinct motion of him raising his arms, and you see the black gun being raised. One more time, please.
You'd agree if that's true. He's doing it. open to the camera.
Well,
so
you know what?
No, I would not say that.
It's okay.
So here's the gun. Puts it down and raises it right here. He still has it up right there, and then he drops it and runs. Would you like the slowed down version?
Yeah, please.
Slowed down version, please. So here's the defendant here. There's the AR-15 right there. Play it, please. So he's coming into frame. He drops the fire extinguisher and he raises it right up. He has it up right there. You see him bring it down, and you see him start to run. He's pointing it at Joshua Zeminski, who probably is vandalizing or committing arson, but that's another.
Where's Zeminski's gun?
We don't believe he has his gun out at that point.
Wait a minute. What?
He fires it.
I didn't hear what the judge
What, I'm sorry.
I said, where's Zeminski's gun? What I meant to say was, does it depict Mr. Zeminski or
Shooting?
Mr. Zeminski's gun?
Wait,
At this point, no. It does show him shoot in the air.
Well, that's over later, over there.
Yeah.
But I'm talking about at this point.
I don't believe it shows Mr. Zeminski's gun.
Does it show Mr. Zeminski?
Can you play it again, Brian? He's kind of
Or
hidden.
Mrs. Zeminski?
They're kind of hidden by this light
I
post.
know that's what everybody is saying. I'm so sorry.
Okay, that's all right.
Is it okay? Do you need me to record this? Because I'm not getting judge what you were saying.
Yeah, because it's argument.
Can you,
What I have inquired is, well, go ahead.
go ahead. No, just go ahead.
Okay, what I'm inquiring is whether what I'm looking at now depicts
Do you want to show them?
Mr. and or Mrs. Zeminski, and if Mr. Zeminski, whether or not it depicts the firearm that he is reported to have fired seconds later.
Where the Zeminskis are?
It's very hard to see them because they're dark against the dark Duramax. So.
We only know they're there because of the FBI video. You can kind of see they're blurry. We did not try to do any enhancements on that.
Yeah. I mean, we know from the FBI video.
I can't hear you. I'm so sorry.
We know from the FBI video, Your Honor, that they're in this proximity alongside the Duramax, but because they're darker clothed and the Duramax is a dark vehicle, and of course other issues with the video, it's not, and there's poles and things, so they're in that vicinity. The FBI video, which we can show you, does give you.
I've seen it.
It might be helpful after seeing this now to see that because it kind of gives you a better idea. So,
If you play it, I think I can play it, please, Brian.
go ahead and play it, Brian.
Be sure if you're going to speak into a microphone.
I believe
I think
they're blocked by the light post, but they are right here.
I think this is one of them here. Moving. It's very hard to tell in this video.
But then they walk down this way, and this is where he pull. We don't accept the defendant's story that he had his gun out because in the video you clearly see Mr. Zeminski pull it out of his pocket, fire in the air, and then put it right back in his pocket. So unless he had the gun out and then put it in his pocket in these few feet, we're not accepting the defendant's story. In fact, we believe this contradicts his story that Mr. Zeminski had his gun already out because you see on the next enhanced video, you see him pull it out of his pocket and fire it in the air quick and then put it down.
He keeps it down on his side, and he's walking right down the sidewalk yelling, that dude just shot somebody. You can see the gun clearly in his hand.
No.
Well,
Not
I
in this
guess
video.
sounds like a great argument.
But
Did you want to make any observations about this before I make a decision?
Well, you're going to see. I'm cheating here, right here. You're going to see what you believe that you see. Okay. So that question is: does that video provide enough information to give an instruction on provocation?
And Your Honor, how does, if you take everything they've said, and that's true, how does pointing a gun at Zeminski provoke Rosenbaum, who they say they don't know each other?
There's no evidence of that. They didn't call it Mr. Rosenbaum is dead, and it's defense of others.
Well,
and it's pointing a loaded firearm, which is a misdemeanor without any real basis.
well, the evidence, is this okay? The evidence in the record from two people is that Mr. Rosenbaum had twice before threatened to kill the accused. So is it, what is the legal effect of a person who, if he made such a threat, what just legal justification does he have to chase after the accused in such a way as to not put the defendant into a position of being a provocateur?
We are absolutely
That's
not.
well phrased.
We are not accepting the evidence that that threat was made because there are different accounts of where and when it was made, and it's like the only 5 seconds not caught on video all night. So, but like you said, Judge, it'll be a great argument, and I do not believe that simply Mr. Rosenbaum does not give up the ability to be provoked because he may have said things an hour earlier. If this individual, now remember, there is evidence in the record that he was accused of pointing guns at other individuals for property crimes. The defendant admitted he responded sarcastically to one of them. On the video, he sort of sheepishly and quickly walks away after admitting he pointed a gun at someone for property crimes. The state's belief is that he pointed a gun at Mr. Zeminski for another property crime, and this dangerous behavior, pointing this loaded, powerful weapon at someone for, at the most, perhaps stoking a fire that's already been lit, would be provocation. Committing this unlawful act would be provocation for anyone to intervene and try to chase him away, whether or not threats have been made. And I know Your Honor takes these threats seriously, but we've also seen thousands and thousands of threats to kill that have never been acted upon. This guy, Mr. Rosenbaum, was described as a babbling idiot. There's no evidence he ever caused any physical harm to anyone that night. And frankly, even if he had threatened, he had no means to carry out his threat. So, as you said, it's a great argument. There's evidence in the record, not just by video, also by testimony, and there's enough evidence to give this instruction. If the jury does not accept this argument, if we do not meet our burden, that probably is beneficial to the defense, but it should at least be argued as the evidence does support it. And it goes directly in contrast to what the defendant testified to.
Do you want to respond?
Judge, it's been hashed over.
Well, it's the jury's. It's the jury's case, and I think they should make the critical decisions. My decision will be to submit the case to the jury with the provocation instruction, and you can argue the strength or lack of strength of the respective evidence. So I will give that instruction, and I'll give the. You didn't dispute the retreat, did you?
I don't think it's. I did. I don't think it's. If you look at the comments, it's not necessary. It says right in the comments, the committee concluded that while reference to duty to retreat is arguably unnecessary, given the potential relevance of retreat to the reasonable use of force, it's advisable to continue to publish it. It is intended to be optional in the sense that it is to be used only when the trial judge concludes that retreat is an important issue in the case, and the jury's understanding will be aided by a statement of rather than the general legal standard that applies. So I don't think that under these circumstances there's any, can't say it's unfavored, but if you look at the comments, there's no reason, in my opinion, to give it. He does retreat. There's no argument about that, but I don't think it's necessary to be given.
Judge, I believe that it is appropriate in large part because this was, that there is no duty to retreat was mentioned in opening, and I believe Attorney Tarofsky referenced it in a cross-examination that the defendant had no duty to retreat. So I believe that there should be, that's been put out to the jury, there should be a fuller explanation of what that means, that they can decide and they can see if there was opportunity to retreat. We see the defendant has plenty of open space in which to retreat. He does so right after shooting Mr. Rosenbaum. And also...
well, yeah, no, I'll say that. Everybody was scattering then, and that dramatically changes the situation.
If you look at the FBI video where he ran to, there was absolutely no one there before the shooting.
The FBI video doesn't pick everybody up. The FBI video does not pick everybody up. The Zanin video shows it clear as day. There's 100 people over there bashing on windows.
Yeah, the Zanin, I don't remember which it was. I think it was Zanin. Video, to me, depicted a large number of people who were engaging in violent activity. Well, property violence, but it's still, they're using clubs and wrenches or whatever else to be doing destruction to those cars that are right in the area which would have been the path of flight for the accused. And I'm wrong about that?
Yes.
Oh, in this video, you hear the 5 gunshots. You hear the first gunshot, which is Mr. Zeminski, and there's kind of a flinch of the crowd, and then you hear the 4 shots that Kyle fired.
Yeah, let's have a look at it. I sure formed the impression when I looked at it that this is just to the south of the area where the shooting took place, and that there was a very large group of people in there who were intent on riotous activity.
I agree that in the southern portion of the lot there is. The defendant testified that his first instinct was to try and head north on Sheridan, that he could not because Mr. Rosenbaum was there. But as their testimony is that he was somehow trapped or blocked in these rather loosely parked cars, and you will see, I believe in the video, that the route the defendant takes after shooting Mr. Rosenbaum...
I don't want to hear about after, because after, that's a different situation entirely.
All right, well,
watch the video. Let's watch the video.
Shots go right already.
Sure, you can put the sound on if it's there.
So over here across the hospital.
Can you pause it, please? Or go back 2 seconds. The defendant runs here. There's no one in that area.
Wait for the gunshots. Which comes in a minute, 10 seconds approximately.
It seems to me that there's quite a bit of flight from that otherwise congested area after the shots are fired. So prior to the shots being fired, there were quite a crowd there. What?
Judge, I don't believe there's a crowd where the defendant ended up retreating to, but
ended up is after the shooting had occurred.
I understand. So my main reason for wanting this instruction, or our main reason, is that the defense has already stated that there is no duty to retreat. So they've already put that in evidence. I imagine they will argue it again in closings. So I believe the jury should properly be able to instruct on the law on guarding retreat.
Did you want to respond?
Your Honor, he's arguing the instructions. I'll keep my mouth shut.
I'm sorry.
I said he's arguing the instructions. I'll keep my mouth shut.
You saw the video, Judge? There's hundreds of people with weapons causing damage. What happens after doesn't matter because it happens after. And I'm trying to do this on the law, which is that it's unnecessary based on the fact that self-defense is going to be given. And the question is, was the use of force in the situation reasonable? That is contemplated by not giving 810. That's what the committee says.
My inclination is to give it, but if I find it's adequately covered in the other instructions, then I won't.
Okay.
All right. Anything else?
Judge, I don't know if there's any jury instructions. Obviously, this case, anyone can pull up any video testimony of anyone testifying. I'm just wondering if the court feels it appropriate or allowable to play portions of testimony to the jury on closings.
You mean from media sources?
Yes.
Wants to play court TV.
Well, I'm not saying we want to. I'm saying we should talk about it now before anyone tries to.
Well, that's a good point. I don't want to specify one. Court TV has certainly, and I might add, has done a magnificent job in this trial, in staying out of my way and just keeping things going. I think. So I'm not saying you shouldn't follow that. You could use any source that is carrying it, except not one where they're commenting on it one way or another. Of course, no one would do that. At least not if he knew it was good for him. So unless there's some objection, I don't have any problem with that.
I don't think it's appropriate.
We're not seeking to do it. I just wanted it out there before someone tried to do it.
I'm happy to agree that we're not going to do it.
Oh, okay. Well, let's do that.
I just didn't want to be blindsided.
Let's do that. Okay, so there won't be anybody doing that. Now, but you bring up a good point. If the jury goes into deliberation and wants to look at some of this evidence, of course, one would read the law, I think, nowadays to say that any scrutiny by the jury should be in the presence of the court here in the courtroom. I very, very strongly disagree with that. I think that's antiquated. I think that that's based actually on a case I tried right here. Once again, I was there. State against Maurice Pucci Franklin. And I'm not going to go into my usual dissertation on that, but that led to, I think, the Anderson case about showing videos and things. The law actually developed around recorded statements of the accused as opposed to videos of the actual events. But I think the general rule now is supposed to be that we're supposed to do all this under judicial scrutiny, and they have to ask permission, and then we have to supervise. One of the things that I find most offensive is that we've got to scrutinize it to make sure they don't play it too many times, so they don't overemphasize some aspect of the evidence. I think that's what the cases say. And I think, how dare us, the founders of the Constitution, have juries because they don't trust the judges, and the judges have spent the last 225 years returning the compliment by always suspecting that the juries are going to be up to no good. If this were a bench trial and like this, I watched it. How many times have I watched that video now? And you know what? I could sit and I could watch it maybe 50 more times. And in fact, the famous Boston Marathon bomber was resolved because an agent from the FBI watched the video over and over and over and over again and finally realized what nobody else had caught, which was that Mr. Zanayev, who is now under death sentence, well, temporarily not. We don't know what the outcome will be in the Supreme Court, but that everybody else was looking one way and he was looking the other. And it took numerous times looking at the video to solve that crime. So for me to monitor how many times the jury looks at something, if we're a bench trial and I looked at it 100 times and I finally decided I better not look at it anymore because I might prejudice myself, I'd get reversed because that's an absurd thing to say. So I don't want to sit here and monitor how many times they look at something. I did that once when when it was an attempted murder case of a police officer, and the jurors came down and they're told they can't even discuss it with one another, but they can't resist, and so they're saying, oh, look at that, and then I send them upstairs and they're not looking at it again, and I think that's really frightening. So I think if they want to see the exhibits, we should give them the equipment to see it and let them do what they want with it. So that's what I think. Now let me hear from you.
Judge, I agree with you that is antiquated. I think this is the ideal case where giving them access or setting them up somehow with the exhibits would be great. I saw this as a issue. I did ask people at the Department of Justice to look into it. Not a formal opinion. They indicated they believe it would be reversible error. I asked even if there was a stipulation and if the defendant agreed, and they thought it would still be reversible error under the current law, and also, and I'm not saying it would be ineffective, but they thought it would raise an ineffective assistance of counsel claim if there is a conviction. I do not want this case to be a test case on long-established law. I agree that the law is antiquated, and with the explosion of technology in the last couple decades, it needs to be changed, and perhaps we can do so legislatively, but as it stands now, the state feels that we should follow the procedures, as antiquated they may be.
Defense?
I don't want them having a free-for-all up in the deliberation room.
Okay. Well, I'm not going to cram it down on this case. One day, with a short trial,
One that you're willing to do twice?
Yeah. This is crazy. It's just absurd. And I'm the one, I guess, who's the dinosaur on technology, but I certainly respect it more than our law does. We need to talk about the lesser included offense instructions, Mr. Rittenhouse. The effect of these, right now, the charges against you, which are stated in the amended information, counts 1 through 6, the district attorney has to prove each of them beyond a reasonable doubt in order to obtain a conviction on that particular count. And there's something called lesser included offenses, and I'm sure your lawyers have discussed it with you, but I want to make sure that you understand it, and I'm required to do that. And if the district attorney is not able to establish your guilt on the charged offense beyond a reasonable doubt, then the jury is instructed that they must acquit you, find you not guilty. If a lesser included offense is presented to the jury, any of the ones we talked about, which are less serious crimes carrying a lesser potential sentences, if I allow those, then the jury, if they are unable to agree that you're guilty of the charged offense, will have the opportunity to consider whether you're guilty of the less serious offense, and could return that as a verdict, as an alternative to instead returning a verdict of not guilty. So you were, by having a lesser included offense included, you're raising the risk of conviction, although you're avoiding the possibility that the jury will end up compromising on the more serious crime, and you're also decreasing the risk that you'll end up with a second trial because the jury is unable to agree. Any question about any of this so far?
No, Your Honor.
Okay. If the jury finds that none of the crimes charged in the sequence, charged or submitted, has been proved beyond a reasonable doubt, then they must acquit you. They must find you not guilty. And they cannot convict you of more than one crime on each count. Okay?
Yes, Your Honor.
Your lawyers have objected to some of the lesser included offenses and not others. They have, on some of them, they have agreed that they're appropriate. You don't have to join in that agreement if you don't want to, and you have the legal right to overrule them. And we'd have to talk more about it if you decided to do that, but you would have that legal right and say, no, I want to go to trial on just the charge offenses, all or nothing, and make the decision to force the district attorney to prove each case beyond a reasonable doubt. That would be your decision. Have you had enough time to talk with your lawyers about this?
I have.
Have you had enough time to think about what you're doing?
Yes, I have.
You think what you're doing is the best thing under all the circumstances?
Yes.
Has anybody threatened you or pressured you or forced you in any way?
No.
Has anybody promised you anything in exchange for this?
No, they haven't.
Is your mind clear today?
Yes.
Are you feeling all right?
Yes.
Have you ever been treated for a mental or emotional disorder? Well, let me ask you this. The more important question is there any reason for me to be concerned that you have some kind of a disability, mental or emotional, that would prevent you from being fully aware of what your options are and making a rational decision? Any reason I should be concerned about that?
No, Your Honor.
Okay. Any other question anybody wants to ask on this?
His pause was, I believe, because he's in therapy. I don't think he has a mental illness or anything.
Okay.
As a result of this incident,
okay,
he has PTSD.
Okay. And but that doesn't affect his judgment or reasoning power at all?
I don't believe so.
No.
He's wagging his head no. Okay. Anything else before I accept his decision on this?
No.
All right. So I'll accept the waiver and instruct accordingly along the lines that I've already indicated. Anything else today?
Judge, while you were doing the colloquy, I looked at my email. I got another screenshot of someone saying they know someone of the jury. I forwarded it along just for transparency reasons to the defense and to the court. Only one now.
I'm disappointed.
I didn't get it yet. Well, wait a minute. Oh yeah, here it is. All right. All right, thank you.